is from there. And one of the more common techniques that I use, especially for small businesses that are selling goods and services, especially services transactions, is you may want to consider something I'm sure each of you have encountered as consumers, is getting a deposit or getting an advance amount of the sales price, or if it's a services transaction, like, I'll use the example of a contractor. If the quote is $5,000 for a project, you may want to get 20% or 15% up front. And by doing that, you're not eliminating your risk 100%. You're reducing it by whatever the amount of the advance or the deposit is. And it also makes the other person, i.e. the debtor, have a little bit of skin in the game. So they know that if they default on their obligations to you, financial obligations or otherwise, then they can lose that money. They can lose that advance, even if they don't finish the project, or even if they do finish the project, depending on how it plays out. So that's a common technique that's used, and it may be something that, for example, the library uses at this point. Maybe it's a little difficult to put community members under the gun asking for a deposit and fill out this credit agreement before you can have a copy of Emily Dickinson, for example. But that's something, a technique that I frequently use on the front end, is I tell clients, assess what your risk is. What do you know about this person or this business in the community? Are they a good risk? Are they a weak risk or a moderate risk? And then go from there. So that is something that I frequently use in especially consumer transactions. The second thing to think about is when entering into a transaction, I always, one thing I stray from, especially for small businesses or for individuals who may be lending money to another person, is I don't want to over-law your deal for you. I don't want to run a big bill for you, drafting a 45-page contract on this transaction if it's only worth $1,000 or $1,500. That said, it is a good idea to think about, and again, this is in the category of assessing and handling what your risk is. Do you want to actually have a contract, a written contract that is, a written contract in place that governs whatever your transaction is? I oftentimes see, when I don't advise a client, I'm not involved in advising a client on the front end of a transaction, but after the dispute has arisen and party A owes party B money and they're fighting over it, is I'll ask, well, what do your papers look like? Are there papers regarding this transaction? Documents, what do they say? And I'll get a small half-page, an invoice, or a bill of sale that pretty much has a very minimal description of the goods or the services, and it has a price on it, and it may or may not reference an interest rate in the event of default or penalties. And it usually doesn't have any signatures on it for many clients. That may be helpful, but it is not optimal, because again, on the front end, what you want to be able to establish is, if I lend this person $5,000, either individually or through my business, and they don't pay me back all of it or some of it, I need to be able to establish what that transaction was all about in the first place. And I need to be able to establish that there was a contract in place, which is basically an agreement by two people to do one thing in exchange for another, in exchange for consideration or money. So you want to be thinking about that. And many times, many small businesses, they're very taxed in terms of personnel. So they're thinking, well, I'm trying to run my business every day and keep the lights on. I don't have time to be drafting contracts, and I certainly don't have the money to hire a lawyer to do it. But you may want to consider investing as a fixed cost in sitting down and devoting some time, or maybe consulting a lawyer for a reasonable fee, to develop maybe a form contract. If you have a business that is, you're pretty much providing the same types of goods and services on an ongoing basis, you can develop a solid form contract that doesn't have to be written and rewritten every time for every new transaction, but it can be something that you get assistance with from legal counsel that you can have on your own to, essentially fill in the names of the parties and what the amounts are, or the dates, and some of the specifics of that transaction, assuming that the transactions are pretty much going to be the same as what you tell your lawyer about at that point, who's helping you on the front end. And if things change, you may want to get updates on any needed changes in terms or changes in laws every few years that are need be. But that approach, it's worth spending a little bit of time and resources on the front end in order to minimize your risk, rather than going into it basically with nothing but a verbal contract, and then it is your word against the other person's word. And that sometimes can actually be more expensive if you actually litigate that and you hire a lawyer, or even if you represent yourself and take yourself out of your business for a while, going to court, going to hearings, responding to pleadings. That can be more expensive than just spending a little bit of money on the front end to try to reduce that risk that may arise in the future. So those things out of the way. Try to think about your risk and determine how you can handle it and how you might be able to minimize it on the front end. I will add a disclaimer here that I am not licensed to practice law in the bankruptcy courts of the United States, and so I'm not qualified to give any law on bankruptcy. Bankruptcy is its own animal, and if you encounter issues relating to bankruptcy, personally or in your business, I would recommend that you locate a bankruptcy lawyer who's qualified to give advice, because it's its own animal. It's like tax. You don't dabble in it. You either do it or you don't do it. So I do not do bankruptcy work. A little bit of terminology. A fancy word for a person who loans money to another person is creditor. I mentioned that earlier. A person who owes money to another person or borrows money from another person is the debtor. So if I use creditor and debtor, that's essentially what I'm referring to. A creditor is someone who's made the loan. Debtor is someone who owes the money. And it doesn't necessarily have to be a loan with a financial institution like a bank. If you get into a transaction where you have loaned money, creditor has loaned money to another person, or you've sold goods or services to another person and you hadn't gotten paid yet, then assuming that even if you do have a written contract in place, but even if you don't have a written contract in place, Virginia law recognizes oral or verbal contracts. So even if you don't have a piece of paper that reflects and details what your transaction is all about, that doesn't mean you can't establish that there isn't a contract. It may be more difficult to do. It will require more external evidence, but you may still be able to establish that there's a contract in place based on a verbal exchange, or even a series of emails that's not as detailed, or correspondence, letters that may be pulled together to establish that there's a contract in place. If you're in the situation where someone owes you money and they won't pay you, you can. There are procedures in Virginia that allow you to force that person to pay you, or you can access a portion of their property to be repaid those funds. And the first thing that a creditor has to do is to get what's called a judgment. And to get a judgment, you have to actually sue that person, file a lawsuit in whichever court applies. Typically, it can be the Children's District Court or the Circuit Court for some higher amounts. And that term judgment, it kind of has a lot of different connotations. but it provides a lot of leverage. It doesn't solve your problem. The judgment doesn't get you your money back automatically, but it provides some leverage to a creditor to allow them to pursue what's called collection efforts. That is the process of actually getting repaid. Collection is getting repaid what is owed to you. And a judgment is essentially it's a piece of paper that is issued by the court that establishes that John Doe has a valid legal debt to Mary Smith, and Mary Smith can then enforce that judgment and work toward getting collection. And once you have a judgment, it allows you to pursue, as I mentioned earlier, what's called collections. And a judgment, to get collections, a judgment debtor can do a couple of different things. A judgment, well, a creditor, I won't use the term judgment creditor because that confuses things a little more, but a creditor may ask the court for certain things to collect on a judgment. Say, for example, the person who owes you money says, I don't have the money, I don't have the assets, I can't pay you back. I know, they admit, I borrowed the money, I can't pay you back. And you think, well, you're driving a new truck out there, and I know you just built an addition on your house over on Elm Street. Seems to me like you've got some resources. So there's a process that it's a process that you go through the court that issued the judgment that allows a creditor to ask questions about that debtor's assets, about what how much money may be in a bank account or savings accounts, what their income is, who their employer is, if they're employed, sources of income, property they own, because that judgment debtor's property can be accessed to satisfy a creditor's judgment.
You know, can I stop you there?
Sure.
I had a situation like that with a renter, and I got a judgment, but I didn't get any of their personal information like social security number or driver's license number or, you know, anything that would help me find that person. And so, I mean, that judgment wasn't worth the time that it took to get it. So when you get a judgment, you know, like this was like for $500 or something. I mean, how do you, for instance, you can't garnish somebody's check unless you've got their personal information. So, like, the judges give you that when you're, is that the mistake you make, that you didn't ask for that personal information in court?
It's not the court's obligation to provide a creditor personal information about a debtor. There's some exceptions to that, but you need to come to court armed with all that information, and that raises a very good point. One of these preliminary matters is that it may seem off-putting to ask for a social security number, which that can be a little bit tricky. It can be very helpful if you do have it later on down the road. One of the biggest difficulties that I often run into in this context in representing creditors is actually before the judgment stage. That is when I'm trying to just find the person to serve them with the lawsuit papers, because these people can be slippery, and they in filling out paperwork on transactions, loan paperwork, they may give their mama's address, and then they give their ex-wife's address, and they give their daughter-in-law's address. Well, I work here, and you can't. Literally, I have spent an inordinate number of hours just trying to physically find a person to
Yeah.
serve them with the lawsuit, because that service is important, as you probably know in our American justice system. A person, has to be served with a claim, generally to have notice of that claim, and so that's a very, very important first step in the process. But I have hired private investigators to go over to Kentucky and basically camp out in somebody's front yard and wait for them to get home from work for supper that evening, just to put the paper in their hands. And so, as Ms. Lowe raises, verify as best as you can. Verify the information you have about that person. Is this just someone who seems to blow in and out of town every couple of weeks, or do you know where they live? Do you know where they're employed? That doesn't mean they may not move or change their employment, but it makes it easier for you to track them. And if you do in your transactional paperwork actually have something like a social security number, or for a business a tax ID number, then that can make it much, much easier than to try to execute on a judgment by garnishing wages or amounts in bank accounts. So that a bit of a digression, but a very important point. So quickly I'll go through these, and I'll go into them more in depth about the process of collecting on a judgment. First is a summons to enter debtors' interrogatories. That's what I was just speaking about. That is, you could formally ask them questions through the court about their assets and their resources.
And that was a summons?
Yes, summons to answer debtor interrogatories. Interrogatories, fancy word for questions. Another sometimes very, very useful process is garnishment. A creditor can garnish a debtor's income or garnish amounts that may be in a debtor's bank accounts, savings accounts. And garnishment is essentially where it involves three parties. The creditor, the debtor, and then whoever controls whatever those assets are. So, for example, in the context of garnishing wages, a creditor can issue a garnishment to the debtor's employer and direct that employer and advise them that by virtue of the court proceedings and the judgment, the employer is directed to divert the income, the payments from instead of being issued to the employee, they can be issued directly to you until the judgment is satisfied, and then it can resume paying the regular payroll. The same thing with bank accounts. If you have a valid judgment, you can direct, say, John Doe has a bank account at we'll just say ABC Bank. Mary Smith can send a garnishment notice to ABC Bank and say, you have a bank account for John Doe, send X dollars here to satisfy this judgment. And that the debtor has very little choice or very little control in that process. They can object if it's a valid objection, but if there's a judgment on file and it's established the money is owed, then generally speaking, there are some exemptions for certain amounts that have to be left in, or certain amounts that the employer has to continue to pay the employee. But generally speaking, as far as the garnishment itself, the debtor has very little control over that process. So you can get your judgment satisfied pretty quickly if that person has liquid assets.
Are there certain things in a bank account that are exempt?
Yes, ma'am. Yeah, there are. Well, it's not necessarily things as amounts. There are, in the law of collections in Virginia, a person can't necessarily have 100% of his paycheck withheld through garnishment. Certain amounts have to, be paid for, exemptions for homestead and basic living expenses. But it
Maybe
can,
I'm wrong, but I've been told Social Security is exempt. Social Security.
yeah,
payments?
there may be some exceptions to that, but I have not actually
Oh, okay.
looked at Social Security. If it's a person who's on, a fixed income, there are some different rules that kick in.
Yeah.
Yeah.
Yeah, because that's
That's a
not
good
earned
point.
income.
Right.
I think it-
Social Security is, I'm pretty sure you're right, it's exempt. So the third thing I'll talk about are levies or attachments, docketing the judgment, creditor, you don't have to take all this down, creditor's bill and equity, and in certain cases, debtors can have their driver's license suspended, which I have not actually been along with. So what is a summons to answer a debtor's interrogatories? The first thing I mentioned. A summons to answer debtor's interrogatories requires that a debtor comes to court on a certain day at a certain time as established by the court, and it's a court hearing essentially. It may not be in a courtroom, but it is a formal proceeding within the body of the court. And the hearing allows the creditor to, as I mentioned earlier, ask questions about income, property, sources of payment from third parties. And the debtor is under oath, the same as if you testify in court or you offer information in court or in a deposition, for example. You're under oath to answer those questions, and so a debtor has to be truthful, or is required to be truthful, or it can suffer the consequences. If you find yourself, well, I won't necessarily go into this because this is mostly debtor-oriented, but it's advisable that if, switching gears for just a moment, if any of you find yourself in the position of being a debtor, that is, someone who's actually dragged into court to answer interrogatories, it goes without saying that you should answer the questions truthfully. You don't want to be held in contempt of court, fined in addition to what you might already owe, or even potentially worse consequences. I have just some observations and something to think about from the creditor standpoint. If any of you are creditors, is these debtors many times come into the interrogatory proceedings really well rehearsed and really prepared to minimize what they have, and some of them have gone to lengths to even transfer some assets, which is a separate topic. Doesn't mean that's not liable for what the debt is, but the point I'm getting at here is that, especially in small transactions, try to do your research as much as you can about, going back to my earlier point, what you know about that debtor, where you think they may work, what assets you think they might own, who their relatives are that maybe you through the rumor mill get information about. So do your research, so that way if you have reason to believe that a debtor is not being forthcoming, is not telling you the truth about their assets, then you can make note of that and pursue that further if need be. Typically, well, the couple of these that I've done, there hasn't been good assessment on the front end, and so these people really haven't had any assets.
Yes, Steve, I'm sorry.
No worries. If a debtor doesn't show up to the interrogatories proceedings, then you can ask the court to issue what's called a rule to show cause, which requires the debtor and the creditor to come to another court hearing, and for the debtor to explain why he, she, or it did not respond to the summons and didn't come to answer the interrogatories. And if a debtor doesn't have a legitimate reason, a valid reason in the court's eyes for missing the interrogatories or failing to respond, then he or it can be jailed for contempt of court. So that's another item of leverage that the creditor has. And hopefully the debtor knows that on the front end and won't get himself into that position. And creditors can also have, through the courts, a debtor arrested on what's called a capias if they don't show up to formal proceedings on interrogatories or respond to interrogatories. So there are some significant leverage that you have as a creditor. What is a garnishment? I mentioned this earlier. A garnishment means basically that the wages, bank accounts, and other money that may be payable to a debtor gets paid to the creditor instead of the debtor. It's a three-party deal. My notes here, yes, going back to the point about Social Security benefits, generally speaking, government benefits can't be garnished, such as Social Security, SSI, supplemental security income, something called temporary assistance for needy families, black lung benefits, unemployment compensation, workers' compensation benefits, and veterans benefits. But garnishment, one of the scariest things for a debtor about garnishment is that a bank account can be frozen and inaccessible. And if you don't object to the garnishment by the deadline, and by the time of filing an exemption claim, you can lose exempt benefits in a bank account. I mentioned that there was I think the gentleman here mentioned he was in lending. Do you mind if I ask, are you with the bank or with the financial institution?
I'm with Farm Credit.
Okay. So I'm sure you're probably aware of this rule in Virginia, is that as of May 1, 2011, a bank that receives a garnishment summons, remember it's a three-party deal, has obligations that it must first determine if the United States or if a state or any child support enforcement agencies had the summons issued. And there are certain procedures involved. I'm sure you're familiar with that. So I didn't know if I would find any banks here today.
Yeah, there's a whole list of people sometimes that are in front of you
Right.
for collecting from folks, and child support agency is one of them, isn't it?
That's right. That's right.
Federal tax liens.
Right.
Yeah.
Yeah, that's a good point, is that just because you get a garnishment doesn't mean that you're your number one priority. You may be, it's great if you are, but there are also certain agencies that may have priority, such as, well, the IRS will always have priority, and child support enforcement agencies. So you may be second or third in line to some of those claims if the debtor owes money through one of those channels.
Not that you can talk people into doing this, but is it feasible? You know, I had a retail business, and I had a service business and a retail business, and I really didn't have anything for sale, either in service or retail, that people couldn't live without. And so, you know, is it feasible, let's say in a library standpoint, to ask for somebody that gets a library card, to ask them to sign a credit card form that says something like, you know, in the event of, and you list the events, and then it says something like, you know, we will not let this debt go over, you know, some dollar amount, and, you know, when it becomes that, we will charge a credit card. You know, I know people have a hard time giving out, I don't give out my credit card information to many, but you know, in certain retail businesses, if people don't have a credit card, you probably shouldn't let them have credit on $150 worth of products or services. Like I had people that would say, well, I don't really have enough money to pay you for, I don't know, $20 for a haircut. And I'm like, well, then you probably need to wait until you get it unless you have a credit card.
Right.
You know, there's just certain things that,
I'm thinking ours, we need to just beef up our wording, because we, you know, it probably needs to say something more than I understand that I'm responsible for these materials and returning them to the library type of fashion, like, you know, that we're gonna be more aggressive in how we.
And maybe limit how many things that can checked out before they check out anymore. You know, once you got 10,
Yeah.
you can't check out anymore.
You get blocked when you owe us more than $3, but, you know, when you took 50 items and you never brought them back, you owe us a lot more than $3.
yeah, right.
Yeah.
But, yeah. I think the documentation on the front end probably is where we need to work on it.
And you can state in documentation, the value of this book, if you will, is $25. And whatever, you'll be charged.
Maybe it would be the doctor.
Yeah, one of the things that contributes to a transaction such as that is, and I'll get into this a little bit, but not too much unless somebody has specific questions about it, is the difference between what's called a secured transaction and an unsecured transaction. My mortgage with my mortgage lender is secured. If I don't pay it, then I lose my house. My house is the bank's security for me repaying the debt. Or if I fail to do it, it's their security for getting their value back, or at least a portion of it. Unsecured transactions are basically when someone loans money to another person without any collateral or on an honor system. I promise I'll pay you, but if I don't, you may be out of luck. You may not be able to collect on it. And I'll be happy to if you have any questions, specific questions about secured transactions versus unsecured transactions, I'll be happy to address those at any time. Earlier I mentioned something called a levy. It's sometimes also called an attachment. A levy is when a sheriff or a sheriff's deputy comes to the debtor's home and makes a list of property that can be sold in order to satisfy the judgment or pay the judgment. As with garnishment and money that's held by a third party, such as an employer or a bank, there are certain exemptions, exempt property that may not be taken or may not be sold to satisfy a debt. And here are some examples in Virginia law. For example, these are examples of exempt property, that is property that cannot be taken. Up to $5,000 worth of household goods, up to $1,000 worth of clothing, up to $3,000 worth of firearms, medically prescribed health aids, which makes sense. I certainly would not want to be involved in representing a creditor and selling some needed health equipment, maybe satisfy a
You
judgment.
can't take somebody's wheelchair.
Right. Wheelchair, oxygen dispensing equipment, for example. Up to $10,000 worth of tools and equipment that the debtor needs for work or school. So if the debtor is, for example, a carpenter, that's how she makes her living, you can't take $10,000 worth of that carpenter's tools that she uses in her business are exempt. They can't be taken away from her because that's how she makes her living. But beyond that, you may be able to live.
Did you say 2,000 or 10,000?
10, I'm sorry, yes. And up to $6,000 worth of the equity value of a motor vehicle, assuming there is any equity in a motor vehicle.
What about things like antiques, family antiques and heirlooms?
Not necessarily. unless it falls within this catch-all category, which is up to $5,000 worth of additional property, plus $500 for each equipment, or it falls within the household exemption. So it may be difficult to split values if you've got a lot of antiques that have a lot of value, and some of that value falls within the household exemption or the catch-all exemption. You may be able to keep some of it, but if it's household goods and it's not a tool that's used in your business, or it's not in another exemption, then yeah, it could be levied upon.
I had a friend that had a situation like that, and again, it was a rental situation, but the guy vacated the house and left he left heirloom, and he left owing the property owner a lot of money in damages that the judge had given the property owner. And then the father of the guy that had rented claimed that those heirlooms were loaned to him. But the judge had already given the property owner possession of all of the items that were left in the house. Now, the guy that claimed that those were his didn't follow through, but if there was a question at that point in time, is could the father have sued to get that property back from the person that the judge had given it to? Because it was left in her rental property, and she assumed it belonged to the guy that rented. But then when the guy's father claimed that it was his property, the guy's father didn't follow up. But that is a really good question as to, there's always some loophole that somebody can go around. And, the bottom line was, probably if the guy had followed through with his own attorney, she would have had to have coughed up those heirlooms.
That raises a very good point, is that, and this can be, as a practical matter, it can be very difficult certainly for a sheriff's deputy or for the sheriff to do, or for the creditor to do, is that if you get a judgment and you go through the procedures of executing or levying property, is how do you know for certain that property title in that property is owned by the debtor? You walk into a household of the typical things you see, pots, pans, furniture, rugs, draperies, things like that. How do you know all that actually belongs to the debtor? Not an easy question.
How many spinning wheels are you going to find at the house value?
Big pardon?
How many spinning wheels are you going to find? I got a spinning wheel that dates back before the Civil War.
Sure. Yeah.
Yeah. How do you get it? I got to find somebody to give me an appraise that for me so I'll know what it's worth.
Could some of that be, or some of those questions or concerns be eliminated during the interrogatories?
Very good point. It could be, yes, assuming the debtor is being forthcoming with you. But they usually, if they are forthcoming, they may forget things. I couldn't tell you everything that's in my house right now, but could certainly make an attempt to. But the question that Ms. Lowe raises is a good one, is that there is some risk there that if you levy property and then you find out, or the person who actually owns that property comes to court and protests that attachment, then that property may fall out of the amount that can be sold to satisfy the judgment. So it's very fact-based, very detailed work oftentimes. Now, if you're going out and there's two pieces of equipment that the debtor owns that can be sold and will easily satisfy 100% of your judgment, that's not such a difficult thing. But if you're walking into a business or a household that's full of goods or property, especially in a business, for example, it may be that The building is owned by Corporation A, the equipment is owned by a separate entity, the furniture is owned by a separate entity, the computers by a separate entity. It depends on who you got your judgment against, which of those entities you got your judgment against. So it can be, you really have to slice things pretty thinly at that point, to know, which items of property are available. And if you get your judgment against multiple parties, then you may not have as much difficulty. But that really comes up more frequently in the business context, but not exclusively.
When you talk about judgments, and if you have a transaction with an individual, and that the individual owns real estate jointly with a spouse, it might be good to elaborate on the collectability of joint owned assets when you only have a judgment against an individual.
Yeah, in that context, if you're talking about real estate, for example, and it's owned jointly by spouses, the judgment will continue to apply to the real estate, and will be a lien on the real estate or a cloud on the title, so that if the husband and wife want to sell their house a couple years down the road, it may be difficult to do that if there's a judgment lien that hasn't been satisfied. But generally speaking, in that situation, to my recollection, you can't force a spouse to sell his or her interest, and if that spouse has nothing to do with the judgment, just to satisfy a judgment of the other spouse. That makes sense.
So in Virginia, that community property rule, that creditor or debtors, that doesn't apply.
And that doesn't mean the judgment doesn't continue. It will continue to be a cloud on the title and to be a lien against the property.
Of the joint property.
Correct, the joint property. Right.
However, you can't force them to do anything with it. You just have to.
Right.
What about, I know a party that the wife worked out of the house. Yeah, I mean, she worked, out of the home and so forth. And she had money. The husband had his own business, contracting business, and ups and downs and so forth. But they had like 8 or 9 rental properties, and all the property was put only in the wife's name, so that somebody who had a claim against her husband's business couldn't attach them. Is there community property, would that apply to that? Or?
If the property, well, I mean, not knowing the specifics of that case, but if the rental properties were titled solely in the name of the wife, but the debt was owed by an entity of which the owner was a member or a owner or a shareholder. Those are two separate spheres, because keep in mind that the entity that owed the money is a separate, distinct entity from the spouse or from the husband, for that matter.
But what about if the contractor is the sole proprietor? Does that change the liability?
Or an LLC?
No, LLC is a separate entity.
Yeah.
So that ties it up, but if the contractor's a sole proprietor, the property's only in his wife's name, but you can get a judgment against him. Can you attach the properties?
If you can show that something called a fraudulent conveyance was involved, and that would be chronologically the way that typically works is that the husband and wife owned 3 pieces of property, or even the husband owned some property, and then entered into contracts, breached the contracts, and got into hot water and was realizing he was going to be sued. He then transferred all of his interest in the property to the spouse. That can sometimes be what's called a fraudulent conveyance. And
Right.
the fraudulent conveyance is essentially where a debtor transfers property or makes a transfer of something, some asset, in order to defraud a creditor, to attempt to escape liability. And in that situation, if fraudulent conveyance is actually proven, then the creditor could still access the husband's interest in the property and have that transfer set aside. It's called set aside.
But
This
if that
one is
spouse
really-
had owned that property for X number of years,
And then,
then it's
Right.
totally and completely separate.
Separate matter, yeah. If the wife had, I'm using the example, if the wife had always owned this property, or it was transferred many years before the debt arose, or before the contract was entered into, that would be a
Well,
separate.
this is a
separate
really curious,
game.
really intermingled situation, and I have too much time here to go into it, but basically, he's a contractor, he's going out and building, doing room additions and things, all the rental properties in the wife's name. At the end of the day, at the end of the week, when the payroll's done up, the workers turned in 40 hours, 30 hours for the company, and 10 hours where he went out to the rental properties to work. The company pays the 30 hours, the wife pays the 10 hours, but it's all handled and, orchestrated through the company.
Mhm.
So it's, how intermingled is that really gonna get? So,
Yeah. Well, not knowing any more than I do about that
Yeah.
that fact situation, I would, if that matter came across my desk, I would certainly probe it more if I were representing a lender,
Yeah.
in order to see what's exactly going on. And it may be that for example, if the husband's getting paid through his contracting company, a percentage of what he's earning, but he's also getting paid through, his wife or his wife's company that owns the rental property, if he's providing service there, then the rental property, if there's a company that owns the rental property, or if it's the wife that owns the rental property, and she essentially owes him money, there may be some wiggle room for potentially doing a garnishment, but again, it would depend on the specifics of the case.
And there's a whole different, the Code of Virginia, actually, there's a whole set of rules for contractors and contractors' actions. And so then what you do is go after the contractor's license based on those rules.
Yeah.
And the court actually does, the courts look at that under contractors' rules and not creditors' rights, I think.
That doesn't
Yeah.
Yeah, it would be an interplay of the two bodies of law, but if you're dealing with contractors are, as Ms. Lowe mentions, there's specific rules and procedures that apply to.
Right, because they're
Yeah,
licensed.
Yeah.
Anybody that's
They're-
licensed, there's another whole set of rules.
Mhm.
So, for instance, Farm Credit, those kinds of credit agencies have banking regulations that they have to apply, or that apply to them. These title loan companies. I know since I've been on town council, the General Assembly wrote some laws that said, okay, you're milking these people too much, you can't do this.
Mhm.
That, you're limited as to what you can do and how you can do it. So I think that probably the most difficult creditors' rights are those smaller transactions that you might let get out of hand. And I think the bottom line on all that is, if you disagree with me, is don't let it go past 30 days.
Correct.
Anything past 30 days, you are taking a huge risk. So, on day 31, frankly, even child support enforcement, on day 31, you need to just go ahead and file and, take the bull by the horns and not let time elapse, because the time is where the liability grows.
That's exactly right.
And a lot of this feeds right back to what you were talking about, or what you do on the beginning, what you do on the front end, with your documentation, with your communications, with the understanding, with the information that you have. Because if you do all that on the front end, it makes things cleaner as you move along, especially if you have to go into the collection process or litigation process.
That's exactly right.
So we're at 1:30. Does anybody have any questions that you haven't had answered?
No, the one thing that, there's a difference between dealing with an entity and dealing with an individual. And that is,
Right.
especially in small business end, where you may have a contract, with an individual, and you collect against that individual. But if you have a contract against an LLC, then that's a totally different book, because
Correct.
things are structured differently. And I didn't know if that was something that anybody might have any questions on, or if you could elaborate very briefly
Sure.
on the differences of collecting versus an individual versus an entity.
Sure. Yeah, that's a very, very good point, very good question. Well, the procedures are generally the same in terms of the general body of law, collecting against an individual versus an entity like an LLC or a corporation or a general partnership are the sort of the three big ones that I most often see, especially LLCs and corporations. But something that is sometimes a little difficult for my individual clients and for my small business clients to understand is that even though John Doe is the one who walked into your office and purchased the goods or purchased the services and owes you the money, or you think owes you the money, it depends on whether those goods and services were provided to the individual John Doe or to his company, a company that he may have an ownership interest in, but they're not one and the same. Because as I mentioned earlier, a business entity like a corporation or LLC is viewed as a separate and distinct entity from the individual that may own it or that may be the shareholder. So you may think that you need to sue the individual that you know they have the face-to-face relationship with. But it all depends on, again, this is another reason why a contract on the front end is a good idea, so that you know with whom you're dealing or with which entity that you're dealing. It may be that you don't have any remedies against that individual because that individual didn't sign in his individual name. He signed as John Doe, sole member of Corporation X. And so your remedy and your procedures would be against the corporation, generally speaking, in that situation. So it raises a good point between the sort of the big universes of the individual consumer versus the entity consumer.
Is there a time limit to sue, to go after money after so many years? How long?
Yes, in Virginia, the statute of limitations for if you have a written contract, if you can establish a written contract, is generally it's 5 years from the date of the breach, unless the written contract falls within what's called the Uniform Commercial Code. If it's a sale of goods between two business entities, then the statute of limitations is, I think it's 6 years. But if you don't have a written contract, or you can't establish a written contract, and all you have to go on is a verbal contract, the statute of limitations for a verbal contract in Virginia is 3 years.
How much?
3.
3 years for verbal?
Are verbal contracts hard to establish in a court? Or are they harder to defend, if you will?
The answer is it depends, because if a party is trying to prove the existence of a verbal contract, or if the existence has already been proven, but the other party is trying to dispute what the contents of that, or what the subject matter of that verbal contract was, or how long it was supposed to last, or what the goods were, or the services that were to be provided, all that information, or those disputes are going to be governed by the facts. What can you establish factually? Well, we agreed I would sell him 100 pounds of concrete. He only paid for 50. I want to get paid for the other 50. And the other party says, no, I only delivered 50. I didn't deliver any more. I don't know why he would believe I said I would sell him 100. So those are the facts. What was actually delivered, what was paid for, versus what the other person thought he was going to have to pay for.
Mm-hmm.
Jimmy in the shop says, well, yeah, he delivered 100. He delivered 100 pounds. I don't know why he didn't pay for it. So it's oral testimony. Tickets about what was delivered. Can get pretty colorful sometimes, as you can imagine, even in corporate transactions. So verbal contracts generally can be more difficult to establish, or their contents can be more difficult to establish than a written contract. In writing, you have something there tangible that the court can rely on to interpret the contract. One last piece of advice, I try my best to give practical advice as often as I can, is if you find yourself in the situation as a creditor, someone owes you money, you've hired a lawyer, that lawyer has spent 10 hours working on this matter for you, and you've paid that lawyer $2,000 already. The debt's only $3,500 or $4,000. One thing I tell clients, especially small business clients, is sometimes the hardest piece of advice I have to give is, or recommendation is, you need to consider when is it a bad idea to throw good money after bad money. If it seems like the likelihood of you recovering that debt is getting less and less each week, then it may be a good idea to stop.
Cut your losses.
Cut your losses, yeah. Stop. As much as I like to get paid for legal work, I don't want to get paid if it's going to ultimately be a disservice to the client
If
financially
you
or
have to
otherwise.
sue, if that's something somebody owes you, can you sue for legal fees?
Again, if it is something that, if you have a written contract that allows you to do that, yes, you can sue for them. It doesn't mean you'll be paid for
Without a
them.
written contract?
Again, it depends on the kind of transaction.
Okay.
For example, there are consumer protection acts that if a consumer, that is an individual that isn't affiliated with the business, proves that an entity violated consumer protection laws, there's some consumer protection laws that allows that individual to recover attorney's fees. It's in the statute, so you don't have to have a contract for that, but it's statutory. And other types of claims, as Ms. Lowe alluded to earlier, depending on if you're dealing with a contractor, or you're dealing with a bank, or a financial institution, or a payday lender, for example. I don't know the universe of laws on this, but there are some transactions where you may be able to recover attorney's fees by statute, even if it's not in your written contract. It would depend on the type of contract you have.
So I'll give the library a plug before we end. They're in the process of putting in they have a law library, but is it Mickey's? Is that the name of it? But apparently there is a set of rules called Mickey's something that the library is getting ready to put in. And honestly, if you do the research for your attorney, then they don't have to spend so much time doing it. So sometimes you know, you can utilize your library, give your attorney is only as good as the information you give them. And so you can kind of give your attorney your contract, what you think you found on this, and then they can tell you up front if you've done the right research or not. But sometimes if you're willing to work with your attorney to help them in their discovery, that can also be of help. Now, you don't want to be surfing the internet and telling your doctor and your lawyer what you found on the internet. Anyway. Because we all know that everything you find on the internet is true, right?
It's all true.
Thank you.
All diagnosed
Thank you.
ourselves.
All right, so thank you all very much. We're sorry for the delay, but I think it was worth it, and we appreciate you coming today and helping us out.
Thank you.